Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have a webinar conducted by Rick Sissman, a construction lien law expert. Today's topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. Today, if you do have any questions, please make sure you request your questions on the right-hand side. Do not include names, company names in your questions, please. So without further ado, I introduce Rick Sissman.
Good morning, everyone. My name is Rick Sissman. I'm an attorney that's been practicing Maryland, D.C., and Virginia. I'm here to discuss today predominantly Maryland issues, including that of mechanics liens, and how to protect yourself in your contract. And it may bleed over into other jurisdictions. So I will start the seminar, the webinar at this point. And Ariella, if you'd like to go to the next. All right. I presume that many, since I've been doing this, subs and primes and suppliers have come to me indicating they have a problem. They're not getting paid. That's the most important issue, is for a contractor to get paid. So I'm here to discuss very briefly what you can do to protect yourself in order to get paid, or the possibility of a better probability of getting paid. And no matter what jurisdiction your project is located, I always recommend getting a signed contract. If you are the prime contractor, the owner may require you to sign its contract, or in the alternative, you can present your contract to the owner. In my experience, normally an owner will have a contract for you to sign, so unfortunately you're going to be bound to the terms and conditions of the owner's contract. However, you as a prime may have some wiggle room to negotiate certain terms and conditions. And as to subcontractors, most probably the prime will have its contract for you to sign, and therefore you may have some wiggle room. Now, in the contract, there are many variations of a type of contract you're going to sign, and most of you know this is either a fixed fee, time and material, or cost plus contract. And a lot of the upper tier contractors, such as owners and primes, will probably present you with what's called an AIA contract for you to review. Now, in your contract negotiation, make sure that there is an attorney's fee provision that is in your favor, whereby if you must litigate, the provision provides that the attorney fee can come your way and not to the other party's way. But most probably, in your own contract, I always suggest that it is an attorney's fee provision, and in a commercial transaction, it's permissible that the attorney's fee go in a one-way direction. However, there are in Maryland, there's a commercial law statute saying that unless it's unconscionable, the court will enforce. As to unconscionability, I believe it's a high threshold to be made. So I think one of the first things you look for in a contract or in the body of your own contract is that you have an attorney's fee provision. Now, let's talk about interest in the body of your contract. If your contract provides that you're entitled to prejudgment interest and you win your litigation, it's discretionary of the court. And in Maryland, for the most part, the judge will award contractual interest, of course, only if you win your case. And it's called prejudgment interest. Each state has a usury law, but in my experience, if you're asking for interest between 12%, and I've seen contracts, especially supplier contracts, that go up to 24% per annum. So if you're on the other side and you don't like that interest rate, if you default, say you're purchasing from a supplier, see if you can negotiate with the supplier to lower the interest rate. In my experience, it really depends on the branch of the supplier that you're dealing with, but it's considered that they may be willing to negotiate a lower rate of pre-judgment interest in the event of a default on your behalf. Because as some of you may know, when a supplier sues you, they will seek pre-judgment interest along with their attorney's fee, because most part they'll have an attorney's fee provision in the body of their supplier contract. Now, also in contracts, from any perspective, whether you're a supplier or a prime contractor, in the body of your contract, if there's litigation, your contract can provide where you must litigate. If you're working with your contract, it's best to have a place to file suit where your principal office is located. By way of example, if you are located, say, in Maryland in Montgomery County, and there is called a forum selection clause, which you should have in your contract, you would probably want that contract, the jurisdiction or the venue, I should say, within Montgomery County. So if any dispute arises, you can have it in your neck of the woods. Now, certain jurisdictions, I'll just digress, for Virginia, by way of example, there's a statutory provision that says any construction contract that is in Virginia, you cannot go outside the state of Virginia to have for litigation. So you should be aware of that. Maryland, as far as I know, does not have such preclusionary clauses. So also, if you're doing work, say, in Prince George's County in Maryland, you can sue in Prince George's County if you do not have a forum selection clause, or you sue where the defendant's principal office is located. Hopefully that will be in the state of Maryland. If not, then I would recommend you sue in the in the county where the project is located. Now, let's move on to change orders. Many contractors have come up against the problem of fulfilling change orders, although the higher tier contractor refuses to give you a signature on the change order. If the contract requires a signature, you should always try to get the signature, but as many of you subcontractors know, they say just do the work and we'll deal with it later. Well, I believe in Maryland, and when I've litigated this issue, if the work has been provided and it was per the instruction of the, say, higher tier contractor, courts will allow you to receive an equitable adjustment or a fair and reasonable value for that change order because you provided the service, it was with the knowledge of the upper tier contractor, and you fulfilled your obligations. So in essence, it's either an addendum to a contract or it is a separate contract where you have offer, acceptance, and consideration. But if the contract does say you need to have an approved signed change order, try your darndest to get a signature. And you could say, per the contract, look, it requires it, I need a signature. I know that's contrary to what happens in the field, but there are always ways, in Maryland at least, to deal with that issue and try to get paid for those change orders, whether signed or unsigned. Let's go on to joint check agreements. Subcontractors and suppliers can request a joint check agreement. The Prime Contractor will issue a joint check with joint payees so that you can be assured of getting paid. Material suppliers do write joint check agreements, or I call them JCAs or JPAs. However, many prime contractors will place many contingencies in the joint check agreement, so it does not act as a guarantee by them that if a joint check is not issued, that they're not guaranteeing or being obligated contractually to pay you. And a lot of language, if you look in those joint check agreements, it's more of just an accommodation. So you have to be very careful and looking at those joint check agreements before you sign them, because many of them really are not more than anything of an accommodation, basically meaning there's no contractual relationship between you and, say, the prime, if you're a supplier, by way of example. So I think that some suppliers have their own joint check agreements, and of course that would be for their benefit, of course. So if you're going to sign a JCA, make sure you read the language contained therein. Also, I would highly recommend, by way of a prime contractor, if you're going to be using a joint check agreement, please make sure that your sub comes to your office or in some fashion endorses the check so that you can tender that check to the lower tier sub, because I've seen many instances over my years where, unfortunately, the prime trusts its sub, and the sub will then either do a forged endorsement and or just over a missing endorsement. And unfortunately, the bank will put it through. So what you have is a problem now where you're not paid, you're totally out of luck, and then there's an issue where trying to go after the depository bank, and then the banks are fighting with each other. You don't want to get into such a mess. So as a prime contractor, or even a lower tier sub, if you're issuing joint checks, I always recommend the endorsement from that lower tier come to you and endorse, and then you take care of tendering that check to the intended beneficiary of the joint check agreement. On mechanics liens, very briefly, I will only be dealing at this point with Maryland mechanics liens. In Maryland, has placed a statutory provision that forbids a waiver of lien rights. However, there's an exception unless the waiver is in a separate document signed after your contract is executed. So if you have in your boilerplate contract between you and your upper tier that says you waive all lien rights and your project is located in Maryland, that is strictly forbidden and will not be enforced by the court. But be wary, because in the event they send you a subsequent document that you waive your lien rights, that could be enforceable. Now, however, as many of you know, throughout the process, you're given partial waivers and releases throughout a construction project. When you give a construction draw, you submit your AIA with your application for payment and your schedule of values. The contractor expects you to give a partial waiver, and I always recommend that you want to put conditional language in that partial waiver and release, and this is not a final waiver, that states that this partial waiver and release is conditional upon getting payment. So you don't want to waive any rights to lien in the event that you don't get paid, because there's a failure of consideration. So it's called a conditional partial waiver of lien. And also you can do that on a conditional final waiver of lien and release, usually. So that language, and I always recommend to my clients that we put that language in the body of your partial waivers where you have the conditional language that we just discussed. As to mechanics liens, there's a several-step process for filing mechanics liens in the state of Maryland. If you do not have contractual privity with the owner, now in Maryland, the owner is defined either as the landlord or the person or the entity that owns the property, or in the alternative, if the contract, say the prime contractor's contract is doing a build-out of a store, we'll use the commercial property, of course, then the owner is deemed the tenant. So you have to be very careful as to what you're naming as the owner. What I always do is I will name the landlord and the tenant, if there is a tenant, in the body of what's called the Notice of Intention to Lien letter, and this is for parties who do not have contractual privity with the owner. So if you're a first-tier sub or supplier and you're dealing with that of the prime, and just to let you know, there's a level of tiers that can file. Only 2 levels down are covered under Maryland lien law. So if you're a 3rd or 4th tier subcontractor, you do not have lien rights. Just very briefly, as I digress, D.C., only a prime and a first tier have lien rights. And in Virginia, I believe the tier level could go as many levels down as possible. But getting back to Maryland, so on the lien level, on the Notice of Intention to Lien letter, that must be done within 120 days of your last day of work on the project. So that Notice of Intention to Lien letter does not cloud title on any real estate. It is literally a letter that is served upon the owner, which could be the tenant or the landlord or both, but it must be in their possession within the 120 days of your last day of work. So please make sure that if you intend to go forward that route, that lien letter is either personally served upon the resident agent of the company, if it's a corp, an LLC, or LLP, or if it's an individual, upon that individual. And it could be done by certified or registered mail, but you're taking a little bit of a risk there. So if that's not possible, then your backup on your Notice of Intention to Lien letter, you could use alternative means of service, which would be via posting. And then with the posting issue, you would have a witness with you at the time of posting on the property that you did your work. Now, what do you do if you have to go to the next level? Under Maryland law, you have to file what is called a petition to establish and enforce your mechanics lien. So let's say you're a lower tier sub without contractual privity with the owner, landlord, or tenant. You file a lawsuit within 180 days of your last day of work. So it is not from the 120-day notice letter, so you do not count your 180 days from when you serve your Notice of Intention to Lien letter. So you must be careful to go back to that last day of work, and that's when you count your 180 days. And this entails where you actually file what's called a petition to establish and enforce. And that's a fairly complicated lawsuit, and you should deal with attorneys who know construction disputes and the lien law in your jurisdiction, including that of Maryland. Once your petition has been filed, summons will issue by the court, by the clerk, and that summons must be served with a show cause order. Now, the purpose of this show cause order is that you must have a hearing, which is called a probable cause hearing, within 45 days of the date of the petition being filed. But by consent, you can extend that out with consent of the opposing party. So let's say you get service upon the owner and you have a show cause hearing. Now, what does that entail? The show cause hearing is in the circuit court, and what happens is that you have to put on your case, and you must make the threshold of probable cause. And probable cause, the threshold is not as high as preponderance of the evidence, which is in a civil case if you're trying on a contract action. So it's a little bit lower than that of the standard of preponderance of evidence. And normally, if you meet that threshold, the court will grant you what's called an interlocutory order. Now, what's that? An interlocutory order basically says you've met the probable cause determination, and that as a matter of right, you're entitled to an interlocutory lien upon the project. And that could be against either the leasehold interest, which is the tenant, if that's the owner, or that of the landlord if the landlord is in contractual privity with that of the prime contractor. So that order will actually encumber the real estate, and normally the owner will try to basically bond off that lien, and there's a process for bonding off the lien so it doesn't encumber the property, because if it's the landlord, it probably has deeds of trust on the property, and that would be a breach of the deed of trust. So normally the lender who would find out would say, hey, it could either be under construction draws or any other lender saying you need to remove this lien. And what the benefit to you is it'll be a pot of money placed in the court's registry so that if you're successful in your final hearing, you can go after the bond and the monies that are within the court's registry. So we've gone past that of the interlocutory order. Once you've gotten that order in place, the next step is a trial under the statute must be held within 6 months of the date of the entry of the interlocutory order. And that is a full-blown trial, and the standard is preponderance of the evidence, which is basically a civil action. It's an equitable claim, which means only a judge can hear. It's a non-jury trial. A lot of times for my clients, I would put in a contract action, and sometimes if there's a guarantee action along in the petition action. So you may have a bifurcated type of trial where you're going to have the judge dealing with the mechanics lien action, and then it could be a jury if there's not a waiver of jury demand in your contract. Most construction contracts will have a waiver of jury trial, so you're precluded from having a jury. But sometimes these contracts may not have that. And in my opinion, I would stay away from juries when it comes to construction disputes due to the complicated nature. Now, in Maryland, as in other jurisdictions, for that, there may be an arbitration clause in your contract. What has happened is that with your petition in Maryland, your petition then, the other side would say, we need to stay the petition, and we go to arbitration, and we deal with the contractual obligations under the binding arbitration, which could be with American Arbitration Association or McCammon Group. There are various arbitration forums that you can go to. Once you are successful in getting your final lien in place, then either, most probably by that point in time, you will work it out with the owner or the tenant. Now, in Maryland, I need to mention to you that there is a thing called the 15% rule and the 25% rule for mechanics liens in Maryland. Let me just tell you briefly what that is. If you're not doing a new construction and you're doing rehab work, let's say it's rehab on a commercial property for an apartment building, the scope of the entire contract, not just your portion of the work, but of the entire contract. So let's say you're a first-tier sub. As to your prime contract, you look to the prime contractor's contract, and the value of that contract has to improve the property by 15% of the underlying value of, say, the apartment building. Now, how do you figure that out? Well, I usually go to the land records to see what the tax assessed value is, but there's case law in the state of Maryland saying you basically need an appraiser to come out and give a valuation as to what is the value of that apartment building. And, of course, that could run into millions of dollars. So, quite frankly, if it's a rehab job, it's conceivable that the value of the entire contract by the prime contract, which would include that of the subs and suppliers, may not reach that threshold of 15%, so your lien suit may not be of any value. So what I always recommend to my client is, before spending a bunch of money, is to make the determination whether that threshold value can be met. Now, as to leasehold interest, it's different in Maryland, where the threshold is 25%. Well, you're saying 25% of what? And it happens to be 25% of the leasehold interest. And to this day, I don't know what valuation there is on that issue of getting 25% valuation on a leasehold interest. Normally, if you were successful in your tenancy mechanics lien, you basically would be stepping into the shoes of the tenant and taking over the tenant's interest. But as a practical matter, the landlord there would be a material breach, and the tenant, of course, would be evicted. So it really has no teeth to it, quite frankly. However, if you were to go the route of going after a tenancy interest, assuming that is what is deemed the owner, the leverage you have is that the landlord will say to the tenant, get rid of this lien problem, or you'll be in material breach of your lease. So that gives you leverage for the tenant to work something out with that of the prime, and hopefully with you. If you're the prime contractor, that also gives you leverage with that of your customer. Now, for that, anything else on mechanics liens, there's a bunch of other caveats, but we won't address that at this point. Ariella, is there anything else that needs to be discussed?
Actually, I think you did such a sensational job. And I think one of the questions that came in was a very interesting one, which is many states, you can, depending on what, some states you have to send preliminary notices in. Some states, like in Maryland, you send an intent to lien, and then you could lien it right away. But this one person's asking, so wait, filing a lien is almost filing what you're saying, a petition. You absolutely need an attorney to file that petition. So that's the case, right?
Well, if you as the claimant are a corporation, an LLC, LLP, anything other than a natural person, yes, you must be represented by counsel. But if you're, say, John Smith, trading as ABC, whatever, you would have a right to file the petition, which is which is a lawsuit in the court. However, any company and a corporation, LLC, LLP, or an individual can do their own notice of intention to lien letter or through their agent, such as SunRay. So, SunRay is very capable in doing the notice of intention to lien letters. But then from there, if it goes to this next stage, I would highly recommend hiring an attorney who knows what they're doing. And it's necessary for that of a non-natural person.
And I agree 100% with you, because this isn't very simple. This is a very complicated process, and one small mistake in filing the petition can essentially eliminate your lien rights. So we highly recommend Rick Sissman to file those petitions for you. I don't actually see any other questions. What I'm going to do next is we have 2 more webinars for the state of Maryland. What happens after I record my lien? How do I get paid? On March 9th, and then don't sign a release unless it says this one thing on April 6th. And I just want to thank Rick. You did such a thorough and incredible job. Thank you so much. If there's anything else you'd like to share, please do so. Otherwise, his contact information is here at the bottom, his phone number. He's extraordinary at getting back to his clients. If you don't receive an email back within that business day, wow, something has happened, because one of the most incredible attorneys has written his response time.
Well, thank you, Ariella. And if there are no further questions, everyone have a great day, and I appreciate the opportunity to speak to everyone.
Great. Thank you so much, everyone, and I wish you a sunny day.